Sticking with the world of AI, the New York Times following this copyright lawsuit against OpenAI and Microsoft yesterday. The Times is accusing OpenAI of stealing its content to train its large language models. OpenAI responding, saying it respects the rights of content creators and owners. Our next guest, though, saying this is a, quote, well-crafted lawsuit. Vanderbilt University Law School Chair and Intellectual Property Program co-director Daniel Gervais joins us now to unpack the suit and what could come next. Daniel, it's great to have you. Why do you say this is a well-crafted lawsuit?
Well, thanks, Sarah. Thanks for having me. Well, I think that the lawyers learned from some of the previous lawsuits. This is obviously one of many lawsuits against providers of large language models like OpenAI. And some of these early lawsuits had issues. Some of the claims were dismissed very early on what we call a motion to dismiss. And I think this lawsuit is crafted in a way that it will probably mean that it would survive this kind of early motion. So that's definitely a lesson learned by the lawyers. The second thing I would say is typically a copyright lawsuit is basically saying something like, you know, you copied something and you owe me money. But the lawsuit, the very first line in the complaint is that we need independent journalism for democracy, so that it's a lawsuit that's really not just about money. In the way that they've couched it is really about the future of journalism. Well,
and what you say here is that it's about the gripe is about the input and the output, what goes into the large learning models from New York Times, and then what competes with it, and how it's often wrong and misrepresented. And I wonder if that's a sort of new element than some of these other lawsuits, which are just claiming that the information that goes in is stolen.
Yeah, there are two very distinct copyright claims, in addition to a very interesting trademark claim that the New York Times is making. But the two copyright claims are basically when you train your large language model, you make a copy of our articles. They say millions of articles. We don't have the exact number. And they say that's copyright infringement. And then they say when you ask ChatGPT or Bing, you know, give me information about something, they give specific examples of articles from the New York Times that were quoted verbatim in the output. And they say that's also copyright infringement. And in both cases, the defense that we should expect from OpenAI and Microsoft is that this is all fair use. In fact, the complaint says that the defendants have publicly asserted that this is fair use. So the debate will be about this thing called fair use, which is a defense to copyright infringement.
Yeah, Dan, Bob Pisani here. I wonder what the chances are of them winning this case at this point. First of all, I'm a member of the Authors Guild. I had a book out last year, Shut Up and Keep Talking, and I was one of thousands of authors, of the members of the Authors Guild, that signed a letter to these companies asking them for more transparency on how they use our books to train their AI systems and potentially leaving the door open for a compensation. So what are the chances the Times could win this, and what would be the implications? Would, for example, all of us authors who had books used to train these AIs be suddenly subject to potential compensation? What's the knock-on ramifications here?
That's a great question, Bob. So when you talk about the expected value of a lawsuit, you kind of multiply the chance of success by the potential dollar amount. And on the copyright side, the law says that the plaintiffs can ask, they're not going to get that, but they can ask for $150,000 per article. And they're talking millions of articles. So you can see how that's a catastrophically large number potentially. Now, obviously, no court's going to give that maximum, but it could be a very large award. So the real question is your question. What is the percentage? And that's very difficult to predict because there are a couple of precedents that courts will look at here. The one that you just mentioned, the Google Books example, is the one that OpenAI will probably rely on. The court said it was fair use for Google Books to copy all these books to make snippets available. But the Supreme Court in the more recent case involving Andy Warhol's use of a photograph of Prince tightened a little bit one of the fair use criteria. So it's very difficult to predict. So if you're looking at this as a business, as an investor, you have to be looking at a percentage that's going to be within a pretty broad range, multiplied by a potentially very large award. If even part of what OpenAI is doing is not fair use.